Welcome to Behind the Advice, the podcast for Australians living abroad who want to maximise their financial situation. I'm your host, Mitchell Kelsey, a financial advisor at Runway Wealth Management, and in each episode, I'll be sitting down with other experts and professionals to get their insights, stories, and expertise on key concepts for Australian expats, as well as providing my own perspective. With this being a financial podcast, there is a disclaimer, so any information that you hear in today's episode is general information only. It is not personal advice, so it does not take into account your personal situation, goals, or objectives. If you do need personal advice, feel free to reach out to us at Runway Wealth Management for personal financial advice. Welcome back to another episode of Behind the Advice. The topic today is all about protecting your assets through estate planning as an Australian expat. And I'm really pleased to have my friends, Jacob Chester, who's a solicitor and an estate planner at Crest Law, on the episode today to give us the rundown in terms of estate planning for Australian expats. So great to have you on, Jacob. How are you, mate?
Yeah, really well. Thanks, Mitch. I really appreciate having me on, and hoping to share some insights with you and your clients today.
Fantastic, mate. And I mean, estate planning is a tricky area for Australian expats, just with, having to navigate multiple legal systems, tax jurisdictions, and you got, in some instances, conflicting laws as well. So really great to have you on to get your insights in terms of what you've seen kind of firsthand working with Australian expats. And then I think ultimately as well, estate planning isn't always the most fun topic to think about. We're kind of talking about death. It's a little bit uncomfortable. We're having to think about, what's going to happen to our kids when we pass away, for example. So it is a bit of a difficult subject sometimes, but, at the same time, very important. And, ultimately, once you've got a estate plan in place, it's really going to give you peace of mind, which I think is super valuable as well.
Yeah, absolutely, Mitch. Yeah, it's not the easiest topic to talk about. It's one of those things. There's never really a good time to do estate planning. It's not something a lot of people sort of wake up one day and think, I'm going to do my estate plan today. But as I always say to clients, there actually is a good time to do estate planning, and it's when you're alive.
Yeah.
And also when you've got capacity to do one.
Yeah. So true.
That's the problem. It can be kicked down the road indefinitely. And, obviously if you don't have a proper estate plan in place, that can create a lot of problems for your family. Like, you're not going to be around to see them, but can add complications, time and cost, and stress to their experience, not only having to deal with your passing, but also, to deal with your personal and financial situation as you've left it. Yeah. So no, like to get on board with clients nice and early, and it is a process that can be, it can be handled effectively, no matter how complex the situation is, with our help. And we at Crest Lawyers pride ourselves on helping expat clients and being able to help them navigate the complexities and put something effective in place.
Fantastic, mate. And personally, how'd you get into estate planning? You're obviously a solicitor, and you need to be a solicitor to, provide that estate planning advice. What sort of brought you down the road of estate planning, wills and estates?
Yeah. I guess it came from personal experience. I predominantly practiced in commercial law initially. Had a bit of exposure to estate planning and always found it interesting. It was one of those interesting subjects to me at uni, to sort of hear about the estate planning law and think about how it might apply to my own situation.
Mm-hmm.
So in 2017, sadly, my mum passed away, and she, as the lawyer of the family, she'd appointed me as executor of her estate.
Yep.
So I took on that role, and though it was a sad time for myself and my family, my kids, it gave me a sense of fulfillment to be able to help her, when she was no longer here to physically help in person, but to, I guess, help her with her, to finalize her affairs, and I sort of felt that I guess was able to feel that connection with her
Yeah.
for
Yeah.
you know, beyond her passing. So
Yeah.
from that, I guess that sort of sense of satisfaction, I thought to myself, yeah, I think this is an area that I want to be able to
Mm.
help other people with. I think I can, you know, be professionally useful, but also gain this satisfaction out of that professional work and in helping others sort of, prepare for the
Yeah.
inevitable, and also to help their families when it happens. So yeah, it kind of went from there. I got a position where I was in commercial law and wills and estates, and yeah, just sort of event my practice in both those areas progressed. I got the position with Crest Lawyers back in 2022, and I think with contacts like yourself, we've taken that wills and estates practice to the next level. So yeah, really, I guess that's the long and the short of it.
Yeah,
That's how I
no,
got into it, and I'm
such
still
a
here.
yeah, and just such a truly valuable service. So, it's just so essential to your broader financial plan. I guess you could put it in the context from a
Yeah,
financial planning standpoint as well. It's just so crucial because it gives you that peace of mind, and ultimately you're protecting your assets, and your assets are going to those who you would wish them for to go to. Let's change gears a little bit, and maybe we'll just start off with getting into the basics of estate planning. So I'm
sure.
sure most people, have heard of a will, and some of the basic aspects of an estate plan. So a will, power of attorney. Be good to just get a really high level summary from you in terms of what is a will, and also what is a power of attorney as well. We'll get into that secondly.
Yeah, yeah, sure. Yeah, so will's a legal document. It's a solemn document that you needs to be attested by two witnesses for the formalities to be satisfied. And it performs various important functions. The first of them is to appoint the proper people that you would like to administer your affairs on your past. So it's appointing your people to be executors. It also, importantly, if you have young children, appoints testamentary guardians. So it's particularly important when, if you're a single parent, or, to cater for the situation where both parents tragically pass away. So yeah, it gives people the legal right to take guardianship of your children. And it also deals with your financial situation, your assets, and allows for the assets to be distributed to the people of your choosing. I guess there is a law that applies if you don't have a will, but it's very rigid. Like there's an order of priority for the people that will administer your estate. It might not be the people that you want. Like there's law of intestacy, which provides as to who your assets are going to go to in the event of you passing. Again, that might not suit you. So yes, like you can get away with not having a will. Your estate will be administered, but it is the cornerstone of a good estate plan.
Yeah, I think with a will as well, there's so many different scenarios that you might not think about, right? As an individual, you might just think, oh, just part my assets will simply pass down to these beneficiaries. But then there's scenarios that you just might not think about. It's like, what happens if, both you and your spouse pass away at the same time, and then you can go so far down the line where it's what happens. Do you want your assets to go to your, great grandchildren, or your grandchildren who may not necessarily even be born yet? So you can kind of factor in all these aspects of, how ultimately you want to, leave your assets to when, when you pass away.
Yeah, exactly right. And even if you have a relatively minimal estate, or you think it's relatively minimal, if you've got children, like that's a massive under 18, that's a massive reason to do a will, because you get to have a say in what happens to your kids, and also just to have the right people in charge of administering the estate. Like, it's a massive thing, like having the right people in charge of the administration, and some people that might be higher in the order of priorities under the law, they really might not be very well equipped to do the job. So yeah.
And then that's a really good overview in terms of a will. And then we've got another instrument which is kind of forms part of someone's estate plan outside of the will, and those are powers of attorney. So
That's right.
I understand there's different forms of powers of attorney. So you've got general power of attorney, and then you've got an enduring power of attorney, which is obviously there to last for forever, a lot longer than just a general power of attorney. Do you want to just give a real high level summary in terms of POAs, powers of attorneys, and how they work?
Yeah, look, it's another essential part of estate planning. A power of attorney is a legal document that takes effect, under various circumstances. So the difference between a general and enduring power of attorney is the general power of attorney is an immediate appointment. It's an immediate appointment of somebody to manage your or to make financial decisions on your behalf. But general powers of attorney apply only to finances.
Yep.
And so a company might, for example, decide to appoint their accountant or, an employee as an attorney because it's just easier for them to sign off on documents and do business, for example. Equally, like some expats may want to do a general power of attorney to give their parent back in Australia or their, friend or advisor power to make financial decisions on their behalf for logistical and practical reasons, if they're like difficult to contact or working remotely, for example. So an enduring power of attorney is different, and this is the one that really comes into estate planning, and this is a document that applies if you're incapacitated and you're no longer able to make medical decisions for yourself or financial decisions. So it's a really important document in that sense, because if you don't have attorneys appointed under an enduring power of attorney, again, like there's default mechanisms under the law where people can go off to like the relevant tribunal or court to be appointed in the role of a financial administrator or guardian, but it's like time consuming, it's stressful, it's costly. Like it's just a really painful process for people to have to go down. And I've had to help numerous clients whose spouse, for example, hasn't, like, they made wills but not powers of attorney, and they've now got dementia and they can't make financial or medical decisions for themselves, but they're surprised to find they don't have the legal authority to make those decisions on their loved one's behalf.
And I've seen it with just clients not being able to get into their their spouse sadly passes away. They can't access the bank accounts. That's a really problematic thing that can happen as well. It takes months and months, and generally just anecdotal experience, but the financial institutions aren't always, they can be quite rigid. They're not as friendly to deal with when you try to work through the legalities of gaining access to those bank accounts or any sort of financial account, really. So super important.
So much more difficult to do business on behalf of a loved one who's either died or incapacitated if there's no will and power of attorney in place. And the power of attorney, it's for the sake of a minimal extra amount of time and effort at the time you're doing an estate plan, like the savings in time, costs, and stress later on, it's a real no-brainer. So we always 100% recommend to all clients, expats or Aussie citizens,
absolutely,
they have both documents in place.
And how does we've talked about POAs, powers of attorney. How do they differ from an advanced healthcare directive? What's kind of the key difference between those two? Because they are similar, particularly the enduring power of attorney is somewhat similar to the advanced healthcare directives.
Yeah. And I suppose it's worthwhile mentioning at this point as well, Mitch, with enduring powers of attorney, I guess this is a state-based system. So what we've got 8 states and territories here in Australia. Enduring power of attorney and advanced care directives are state-based. So for example, in Queensland, we deal with enduring power of attorney that covers your medical and financial decision-making. Whereas New South Wales, you've got an enduring guardian and an enduring power of attorney. Enduring guardians for medical, you're appointing people for medical decisions, and power of attorneys for financial. And there's a similar situation in Victoria, and WA, for example. So at Crest, like if you are an expat that's come from a state or territory in Australia, we work with your state and territory's documents. Just because us and Mitch are based in Queensland, we don't sort of, force you to use that our document. I just wanted to point that out. But the Advanced Health Care Directive takes the medical decision making one step further, and each state and territory's got a similar document, similar concept. But it's a really useful document for your medical attorneys or decision makers, because it's a statement of your medical decision-making preferences. And where it differs from the enduring power of attorney is that the Advanced Health Directive or Care Directive actually, if done properly, binds your treating medical professionals and your attorneys as to the medical treatment, that it's an advance consent or refusal to medical treatment effectively. Whereas if you're appointing someone in an enduring power of attorney or enduring guardian document to make medical decisions for you, like that's what you're doing. Like if something comes up in your healthcare, like the doctors are going to ask your attorneys to make a decision, or guardians to make a decision on your behalf as to how you'd like to be treated. And you might not have had like detailed discussions with them about like your healthcare condition or preferences in that sort of situation. So that's where the document can be, the Advanced Care Directive document can be so helpful for those medical decision makers. Because it gives them guidance as to what you want or don't want.
And it's really important to have conversations with the person that you're going to nominate as well, right? Like well in advance. And I think also for expats, maybe if you've nominated someone, or if you yourself have been nominated, as someone who is the Advanced Healthcare Directive, like you're the person, and then this was maybe 4 or 5 years ago, and now you're based overseas, you're an Australian expat, it might be worthwhile considering, having your parents, for example, that are back in Australia, updating that as well, just to maybe someone who's in Australia. It probably makes a little bit more sense, so long as they're, a trusted person, of course. But that way, you're not having to kind of upheave everything whilst you're overseas and come back, quite suddenly. So I think it's not just, thinking about your own personal kind of estate plan. It's also like kind of connecting that with your relatives as well, particularly parents as well, if you're an Australian expat. So it's not just your estate plan, it's also you're thinking about, you should definitely be thinking about your parents that are back in Australia. And there's multiple reasons for that as well, not just for convenience in terms of having someone locally, which we'll get into later in terms of some of the tax implications of that as well. So that really rounds out really good high level in terms of wills, POAs, advanced healthcare directives. Something a little bit more complicated, not overly complicated, but not as often used is in estate plans, is testamentary trusts. So I understand a testamentary trust is something that only gets established once someone passes away. It's a really good tool to essentially move that individual or that the deceased's assets into a trust, and then one of the greater benefits is it gives you time for the beneficiaries, for the executor or the executrix to make decisions on those assets. They're not having to kind of distribute them all of a sudden, quite quickly as soon as the estate gets wound up. Can you just speak to when a testamentary trust may be a really good tool for someone to consider incorporating into their estate plan?
Yeah, definitely. Yeah, testamentary trusts are very useful estate planning tool. I think when we're giving advice to clients in the beginning, like when we meet clients and we're discussing and discovering about them and their circumstances, we make recommendations, and often those recommendations will involve the use of a testamentary trust. Like as you mentioned, Mitch, like there's flexibility reasons. Like you're not necessarily binding your trustees to distribute assets quickly and in a certain way. The trust is a vehicle that can receive assets, so it gives the executors time to consider. Okay, well, we've got this asset. It might be a real property in Australia. Okay, now what's the best outcome for this asset? Is it to sell the asset and to distribute the proceeds to the testamentary trust, or is it to transfer the asset directly into the trust? And that's going to depend. Like estate planning's a team game. Like it's another reason why I like it. We work with as a team, lawyers, financial advisors, and accountants at the relevant time to advise the trustees and executors as to how in the circumstances now, because we don't have a crystal ball, we can't predict exactly what's going to happen.
Yep.
In the circumstances when they happen of the deceased and their beneficiaries, what is the best outcome here? So so I think that's a really great tool to have in the kit bag.
Yeah, absolutely. And we were talking, before the call, I was kind of giving you an example of, had a recent client example who, a client of mine, their granddad passed away, and he left through a testamentary trust. He left a sum of funds for his great grandson. So being my client's son. And essentially, those funds were set out in the will, which is which sort of establishes the testamentary trust, and those funds were to be set aside for education purposes and wouldn't be able to be accessed by the great grandson until I believe it was attaining age 21. It might be 18 or 21. So the great grandson's 4 years old right now, and just to kind of showcase, one of the tax advantages of that as the beneficiary of that trust, I understand he is afforded adult tax rates, which means the first 18,200 of any income that he derives from that $10,000. In this example, we had invested the $10,000 for the long term. So any dividends, increase in value, if we're realizing capital gains in the future on those funds, you got this, tax-free threshold of 18,200. So effectively you can invest tax-free for, at least until the great grandson gets a job, right? Which probably isn't going to be for at least another 11, 12 years. So that's just an example of how you can truly leave a legacy through your testamentary trust and really set up, something for your great grandson once they attain age 21, for a house deposit, for first car, anything like that. So I think that was a really great example showcasing how testamentary trust can be used to the benefit.
Great example, and because it talks about the flexibility of like the tax and tax benefits like of the adult tax rates, and
Yeah.
just imagine if that gift was 100,000 or 1 million,
Yeah.
and the investment income from that, like how that could be used to, whereas if the money's gifted to, like, I guess you look at it as if, but for any beneficiary, if you're just going to give them the money directly into their own personal name, and from that point forward, they're investing it in their own personal name, like they might already have a really high paying job and be in the top marginal tax rate. So any investment money they make off that, income they make off that gift is going to be like taxed highly.
Yeah.
Whereas if you give it via a testamentary trust, then and that high paying adult child has kids, then and also potentially a spouse that doesn't work, for example, then that income can be distributed very tax effectively, and that's the teamwork that happens between the three disciplines there.
Absolutely. Really showcases that.
Yeah. So that's, it's a really good advantage of testamentary trust, potential advantage for some families.
Absolutely. Let's shift gears again. I want to bring this back to specifically Australian expats, and a question that I'm often, asked about on initial consults with, prospects and clients is, do Australian expats need a will in both Australia and their host country? I'll let you answer that question.
Well, I'm gonna give you a classic lawyer's answer here. It depends.
Sure.
So, I think if an expat's got significant assets in the country they've moved to, then likely they are going to need a will in that country. If they're really living over in another country and really they're sending their money back to Australia, by and large, then they may not need it. But like, we are licensed to practice law in Australia, and we're unable to provide national estate planning advice because we don't know the law in Dubai, Singapore, the US, England, Fiji, wherever you might be. So we can only guarantee the legal effect of our documents here in Australia. So what I would say is, in all cases, expats should be seeking legal advice in the country where they now reside, and get that advice on whether or not they need a will. And what we do. What we do is we work collaboratively with lawyers in other countries and make sure that the wills we do can operate concurrently with the wills that they do. So, you don't have a will here revoking a will over there, and vice versa.
Yeah, absolutely. And it's kind of like, if you think about the discipline of, being an accountant as well, like you wouldn't have your Australian tax accountant doing your US tax return, or your,
exactly.
Your French tax return. So, and you wouldn't want, anyone that is specializing in doing both, like, I don't know, they're probably maybe not doing as well in one aspect of it, right? Like, you want someone specializing in terms of that local jurisdiction, so you're getting the right service, you're checking all the boxes.
For sure. I mean, you build up knowledge over time, like, about sort of how it works in other countries, but it's too flexibility. You just shouldn't practice being law in another country. Like, you practice in your own country, and we can do estate planning documents that deal with Australian assets. Not to say that, depending on the country, if you don't have a will in another country where you have assets, eventually the Australian will might be able to be used. It just all depends, and
case by case.
Like, why take the risk, I guess, of just hoping for the best? Like, best off to get that advice in your new country, and just make sure that everything lines up in both countries.
Yeah, absolutely. You made a really good point before. If you're starting to accumulate a lot of assets in your host country,
Yeah.
you're going to want to, take those active steps to get a will in your host country as well, just to account for those assets.
Oh yeah, I think so. Yeah, definitely. Definitely that's the general advice I'd be giving all expats. Yeah, get advice, and if you've got significant assets, and particularly if you're in a host country where the language and legal system are different,
Yeah. Yeah.
like, that's going to create logistical problems in itself, having to get your Australian will translated and like things like that if it was to have legal effect overseas.
Yeah. And I know
Yeah,
in the Middle East, you've got, things like airship over there where your assets only pass to a certain person in the family. So
yeah,
you want to
yeah.
make sure in those, particularly Middle Eastern countries, you've got an effective estate plan locally there as well.
Ah, yeah, no, couldn't agree more. Yeah.
So we've talked about, wills, POAs, advanced healthcare directives. Are there any other key documents that you say are really important for Australian expats to have in place for a complete estate plan?
Yeah, definitely. I think there's a few things. Like first of all, we do a letter of wishes, which is basically an explanation to your executors about why you've made the estate plan in the way that you have. And because, I mean, a testamentary trust will is a 30-page document. It's not like a good book or article on the internet that you can just read and
Yeah.
go, oh, wow, that's, what a great read. Like
Yeah.
it needs to be very carefully read. So the letter of wishes gives context around the document and why you've done what you've done. So that's and it can put, and in that letter of wishes you can put personal stuff that things might change over time, and you've got your overall structure in your will that doesn't need to change, but you might have pets, for example, and you want certain things to happen with them, or you might have specific things you want to happen at your funeral, or like that sort of stuff, and that can be put like in the letter of wishes, or specific sort of personal items that you want to certain people to have.
Yeah.
And those can change over time, and so that's a document that we sort of we recommend to sit alongside the will.
Great.
So that's one. And then I think some clients operate trusts in Australia, like trusts. They might have set up an investment trust, for example. Flexibility. And the will, the trust assets aren't dealt with by the will. Like that's an important concept that a lot of clients are surprised to learn about. The rules of the trustee dictate, if what happens if a trustee dies, or an appointer of the trust who can choose the trustee dies.
Yeah.
And who's in control of that trust? Flexibility. Following a decision maker or controller's death.
Yeah.
Ensuring the right people take control of that trust is vital, because they're the ones that make the call from that point on what happens to those assets.
Absolutely. I'm really glad you brought that up, because it's going to be something I asked. What are the assets that are kind of dealt with outside the will, and trusts being one of them. So how do you kind of manage that? It's just making sure that the trust deed is kind of written correctly.
Yeah. The trust deed might sufficiently already provide like the correct succession arrangements. But we need to read the deed and advise for the client to be satisfied that's the case. Particularly like older trusts that were set up a long time ago, maybe before kids became adults, or things like that. And they might have, flexibility. It's surprising what you sort of read in the trust deed sometimes, and it's surprising how far it is from what the clients actually want. So depending on the rules of the trust, we can do side deeds effectively that amend the make succession appointments or amend the provisions. So so what the client wants is gonna happen.
Yeah, I think that's really crucial for business owners as well, because they're, tend to be the ones, particularly for Australians, they're running their businesses out of Australia. They normally have a discretionary trust. It's usually, owning the company shares, or the trust kind of operates the business. And so substantial assets, in that trust, right? Particularly if it's a company that has a value. So you want to make sure that, should something happen to one of the trustees or one of the owners of the business, those assets are, distributed accordingly, but also the business continues, or, in some instances, ensuring the business continuity is secure.
Yeah, definitely. Definitely. Yeah. So no, that can be a trap, for people that don't realize their wills, can't cover that or don't effectively cover it. Some trustees provide for appointments to be made in wills, but some don't. And then, appointments made in wills, like the relevant people might not have access to that document, might not know the appointment's been made in it. Whereas if you're sort of making it by a separate deed that can sit with your trust deed, then everyone that needs to know can be made aware of it. And it can be, so there's succession planning for your personal assets, that's done in your will, and then you've got succession planning for any trusts that you have in place as well.
Absolutely. Makes sense. And I mean, speaking of non-estate assets, probably the most popular, or not popular, most common non-estate asset, not a lot of people know this, but superannuation. Your superannuation funds are a non-estate asset. So essentially, what that means is they can be handled, once you pass away, they can be handled outside of the will. And those benefits, those superannuation benefits, are handled through beneficiaries. So with your superannuation fund, you can nominate a beneficiary, and there's many different beneficiary types. I think the two most common that you see are preferred beneficiaries, or non-binding beneficiaries. And then you've got binding beneficiaries as well. And obviously, as the name suggests, a binding beneficiary nomination is essentially a legal instruction, and essentially your nomination is binding on the trustee of that superannuation fund to pay out your superannuation benefits in accordance with that valid nomination.
Yeah, that's 100% correct, Mitch. Yeah. It's a massively important flexibility to get a superannuation binding death benefit nomination in place when you're looking at your overall estate plan. And like you said, there's various classes of beneficiaries. The common ones are spouse, obviously, and then you've got children, and then certain categories of financial dependents. And they're the only people living that you can make a valid binding death benefit nomination to. Apart from, if you want your superannuation benefits, say you don't have a spouse or kids and you want the benefits to go to your siblings, what you can do to still bind the trustee and make that happen is to nominate your estate to receive your superannuation benefits. And then in your will, like we do provisions in the will that tell the executor where to pay those superannuation benefits to. So if you've got 5 siblings and you each want them to have 20% of your super, you make the binding death benefit nomination 100% to the estate, and then in your will, we make appropriate provision for the executor to know where, once they receive the 100% of the money from the super fund, where you want that money to be paid.
Absolutely. And there's also tax considerations, to think about as well when you're nominating a binding beneficiary nomination, because and this is another great example to show how, working with both an estate planner and a financial advisor is really important, particularly where you're nominating a beneficiary, which might be one of your children. And, generally if they're over the age of 25, if they're receiving a death benefit from your superannuation fund, that's going to be taxable in the hands of that beneficiary. Whereas if your superannuation benefits are paid out to a spouse, for example, that's going to be a tax-free transfer of wealth.
Yeah.
So that's another key consideration when you are looking to make this binding death benefit nomination, and how both, myself as a financial advisor can kind of consult on those types of decisions, but then also having an estate planner that can build that nomination into your broader estate plan as well.
Oh yeah, definitely. No, it's definitely an area where the teamwork between the financial advisor and lawyer is really important. And the rules of the super funds, can be different.
Yeah, absolutely.
As particularly the forms used. There's no like standard form amongst super funds. Or the funds have different forms and different processes that have to be followed to make a valid nomination.
Yeah.
And then there's the actual consideration about who to nominate to receive them. And you mentioned that tax, the super death benefits tax. It's, we don't have an inheritance tax in Australia per se, but that is like a hidden inheritance tax. And if the superannuation death benefit payments aren't handled appropriately, then that tax can be triggered. And it's something that we need to consider when we're estate planning, for expats or
absolutely. And if you're working with an advisor as well, there's some strategies that we can employ. I'm not sure if you've heard of you may have heard of the recontribution strategy. So we look at taking funds out of super, putting them back in, and then it kind of resets the components of your superannuation fund, so that once you pass away, if those funds, if your superannuation benefits are to be paid to a beneficiary who's a tax beneficiary who's not going to receive those funds tax-free, you can at least mitigate or reduce the amount of tax that's going to be paid on those benefits, because in the super fund you got a taxable component and then a tax-free component, and that tax-free component is always going to be tax-free when paid out, but the taxable component is the component of the fund that's subject to that tax, and that's usually making up the majority of most superannuation balances, because it's your employer contributions that have gone in, it's your investment earnings that you've earned off the back of those contributions. So that in most cases we see it is made up, is creating the majority of that superannuation balance overall.
And it is a really complex area, super, and that's why it's so important to get financial advice when you're considering super death benefits and making your binding nominations. It really is something that you need an expert to help with. And as lawyers, we're great at doing the documents, and we can advise you on the different options, but like to get that specialist financial advice to inform those decisions is that's going to get you the best outcome as a client.
Definitely. I wanted to ask you as well about quite a unique tax event that really only applies with Australian expats, and it's a capital gains tax event referred to as capital gains tax event K3. Now, this is a capital gains tax event that applies when an Australian expat is inheriting certain assets. And this again kind of brings it back to the conversation we're having earlier, where you as an Australian expat, your estate plan needs to be aligned with your, I'll use a common example again. It needs to be aligned with your parents back home, because if they're looking to pass on particular assets to you as a Australian expat who's a non-resident, there are additional tax complications that can arise as part of their estate when those assets are passed on to you. So
for sure,
CGT events K3 is essentially capital gains tax event that applies at an estate level. So it's the estate that has to pay the capital gains tax, and it usually only applies to shares. It doesn't apply to your real estate assets in Australia. So essentially, if there are shares that are making up part of the estate, before those can even be distributed to the beneficiaries, if one of those beneficiaries is what's considered tax advantaged, I think as the legislation refers to it as, being a non-resident, then the tax has to be paid at the estate level. So that can kind of give rise to some planning opportunities there, right? Where, usually those shares probably shouldn't pass on to that beneficiary that's overseas. You might kind of restructure the estate plan so it's much more tax optimized and factors in the unique situation of that Australian expat. What have you seen in terms of planning estates where there's beneficiaries that are living overseas?
Yeah, I think that K3 can be a bit of a trap, and I guess that's like having an overly prescriptive estate plan that, I give these shares to this beneficiary, and at the time the beneficiary might have been in Australia, and that tax event's not even a consideration. Subsequently, they move overseas and you pass away. Suddenly there's this tax. I mean, it's a policy. If one of those that event that the Australian government wants to, if those shares are just transferred to the beneficiary, the government's worried they're not going to get that capital gains tax when the beneficiary eventually sells them. So they want it now, from the estate. So,
and it's worth clarifying too that the shares aren't sold, right? It just understands.
No, the shares aren't sold. Yeah,
they're sold on paper, which means that the estate has got to come up with the cash.
Transferred on paper, they're transferred from me to you, in specie. So they're not sold. And having even having a will where you're just giving away your residual estate, like 1/3 to each child, for example,
creates inequalities.
Like if you're giving away like your entire estate and leaving the executor with the flexibility to sell those shares and then, distribute the cash, that's going to get around that event. But where you've got a very rigid will, where you're giving those exact shares to that person, that can trigger the CGT event and create inequalities in the estate, because the estate has to pay the tax, but then there's only one beneficiary gets the shares, so any gifts to the other beneficiaries might be reduced as a result, or intended gifts. So testamentary trust's another good way to get around that sort of thing, because the flexibility built into the decision making at the time.
And that's probably one of the more complex areas of the estate plan that I would think you would come across, but it's also something that is not, you wouldn't know about this. A regular person wouldn't necessarily know that your assets are going to be taxed in this way if you want to pass on assets to individuals that are living overseas. So just one of those unique nuances of being an Australian expat that Australian expats need to be aware of themselves. So definitely. We might round it out there, mate. Today's been a super insightful discussion. I think I've even I've learned a lot throughout the call as well. Really driving home the importance of estate planning, asset protection, tax minimization, and then just help avoiding any disputes. When it comes to the will and distributing assets, having that peace of mind, I think it's just as a person is truly valuable. So I really want to thank you for coming on the episode today, Jacob. We'll definitely have you on for a later episode.
Great, look forward to it. Thanks, Mitch. It's a pleasure, and thanks for the invitation.
Thanks for tuning in to today's episode. If you want to learn more about Runway Wealth Management and how we help Australian expats, feel free to jump onto our website runwaywealth.com, and we're also on all the social media platforms.